I now recognize Mr. Johnson.
Thank you, Mr. Chairman, and thanks all of you for your time today and your valuable testimony. Today, a lot's been said already about federal land management laws, and before we get too far down the road, I just wanted to raise an issue that looks to be fairly common sense and which seems to me to present a critical issue. In 2011, an official report by the Government Accountability Office found that Border Patrol's access to some federal lands along the southwestern border has been limited of certain land management laws, one of them being the Wilderness Act. And this report followed a previous report with similar findings, identifying that Customs and Border Patrol agents in charge of 14 of the 17 stations along the southern border reported that they've been unable to obtain a permit or permission to even access certain areas in a timely manner on account of regulatory red tape. I think this is a major public safety concern, and it seems clear to me the system's broken and that the Wilderness Act is in need of reform in this area. I wanted to ask Representative Cook, are you aware of anything that's been done or is currently being done to fix this problem?
Thank you, sir. I appreciate the question. I'm not aware of anything that is being done at this time, at this level. You know, in Arizona, it's a huge problem. We've lost even some of our ranchers down there because of that have been murdered out in their pasture. So the Pinal County Sheriff is a good friend of mine, and he is constantly telling me about what restrictions are placed down there on the border and that you cannot go through there because of exactly what you said, the wilderness. We think there should be some kind of a buffer zone on that national border. Law enforcement should not be hindered or handicapped or any way handcuffed and not be allowed to protect the citizens of this country.
I appreciate that. This question's for Supervisor Dillon. I'd like to read a portion of a written response this committee received from the Interior Department following a 2011 hearing. It said, quote, "The department has not determined which tribes on the list of recognized tribes published in the Federal Register may not have been under federal jurisdiction on June 18, 1934. The department has consistently stated that it will review tribal fee-to-trust applications on a case-by-case basis." So the question is, are you aware of a tribe ever being denied an application to put land into trust on the basis that the Department of Interior determined that it was not under federal jurisdiction in 1934?
I don't have any knowledge of that, sir.
So according to a 2016 report done by the Oregon Office of Economic Analysis, a casino that was recently opened on land placed into trust on behalf of the Cowlitz tribe will cost the state $110 million per year in video lottery sales alone. Could you briefly describe some ways that localities may be adversely affected by land that's placed into trust by the federal government under Section 5 of the IRA?
I don't know if I have enough time to do that, but I'll make an attempt. When land is taken into trust in the fee-to-trust process, the very first thing is it comes off the tax rolls. And so there's an immediate economic impact there. Tribes are able, because of their status, to engage in activities without regard to the impact on other businesses of a similar nature, without regard to unintended consequences that can occur. For instance, it is not uncommon to see an increase in certain kinds of criminal activity when casinos are established. It's not always the case, but it can happen. There can be impacts to highway systems, which the local government has to absorb. Every single aspect of what happens when you establish any kind of new business, when it happens in the fee-to-trust process, all of those impacts should be analyzed. The mitigation should be established. The department should have a process for making sure that the mitigations are enforced, but that is not the process that we have in place right now.
In your estimation, are the viewpoints of state and local governments adequately taken into account in the fee-to-trust application process?
No, sir, they are not.
Why do you think that is?
I think that the Bureau of Indian Affairs, in its status as a trustee, is intent on taking land into trust for the benefit of Indians. And there's an inherent conflict there, if you will, between that trustee status and its responsibility to Native Americans, and its responsibility to engage in an oversight process, if you will, to consider the impacts on local government and other surrounding communities, can be tribal communities that are nearby, and to balance those interests and arrive at a process that it addresses all the mitigations.
Thank you very much. I'm out of time. Thank you. I yield back.
Thank you.